Okay. This is...
That's the wrong.
No, you just didn't finish. That's all right. Okay, so let me go. Are you Hallie Rawls? Will your client waive the formal reading of the indictment and the motion? Ms. Rawls, in cause number 25 DCCR 0623, you're charged with the third-degree felony offense of possession of a controlled substance from May 30th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? Yes. And are you pleading guilty because you actually did what they've charged you with? Yes. In that case, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Ms. Rawls is not competent?
Hold on.
All right, ma'am. In cause number 25 0623, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number 241987, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 27th, 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? Mm-hmm. It alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 13th, 20th, March 6th, 20th, and April 8th of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not provide verification of performing the community service as required. Is that true or not true? Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true? Count 5 alleges you're behind in your court-assessed fees. Is that true or not true? And then count 6 alleges that you failed to complete a mental health evaluation. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have some documents in that case here on the computer that have your signature on them that the state's marked as Exhibit Number 1. Did you also sign and go over these with Mr. Rogan? And do you fully understand them? State tenders number 1.
Object.
It's admitted. I'm going to find, Ms. Rawls, that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find that those counts true, again, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These sentences will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. West. All right, good luck to you, man. You can go back with the bailiff. We can get that taken care of before. All right, are you Cody Dent? Yes, ma'am. And Mr. Dent has two motion to revoke probations and cause numbers 13-17772 and 22-41052. And there's a new offense, a burglary of a building, in cause number 250807. Mr. Samuel has filed a motion asking that I set a bond in those two MTRP cases. Is that correct?
Yes, Your Honor.
Let me get that pulled up. That I probably don't even need to have a hearing. If you filed the motion and there's, I'll look at it once if you'll just get it all filed with that attached to it. It needs to be e-filed. I'll take a look at it and it's no problem typically, as long as you have that affidavit of indigence.
Yes.
Okay, so are there no bonds set at the time?
Right.
Okay. Are they deferred?
Yes.
They are both deferred. Mr. Smith, what is the state's position with regard to bonds?
I show on that PLP, the one with 5 years. Which one?
Second one, which would make sense if he got on probation after he was already on probation. Give me just a second. I want to take a look at PC and that new offense, and then I'll let you put on any testimony you need. All right, I'm printing something. Do you wish to call a witness, Mr. Samuel?
Yes.
You need to speak up so the court reporter can hear you, please.
Yes.
Mr. Dent, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. Go ahead, Mr. Samuel.
You were changed on probation, and the commission changed that to the correct. Okay, and since that time, you have one story that they go through. Right now, are you presently under the care of any doctor or authority? And are you presently on medication? Yes. Okay. And what medications are you? Don't make me laugh. Okay. Then when you school, you don't have children, is that correct? Yes. And you're only still preventing the from every time. Yes. So that with that, now going to the date in which you were like, that was when it says burglary of the building. That was a.
When probation terms are violated, the court can revoke deferred agreements. Failing to report, complete programs, or pay required fees carries real risk. Judges must balance second chances with public safety.
Okay, I just answered the question you asked. Okay. It seems to be a dump. Is that correct? Yes, sir. You didn't think that was wrong with getting something out. You thought it was trash. Is that correct? Yes, sir. Okay. At that time, had you had your medication? No, sir. I didn't take it. Your Honor, you can leave that. Man, I passed the witness. Yeah.
Any questions with regard to this hearing?
Not what you
Give me a second. I'm reading the pre-sentence report. The PC. So it shows that this was, the allegation is from South Discount Tire.
Right.
And there was a shipping container.
Right.
He was allegedly removing tires and placing them in his vehicle.
Right.
And this, Business apparently was closed. Signs on the container.
And we can show the sign, they're somewhat obscure, but they
Well, but they're on the business
Right.
property with tires that belong to Discount Tire Business.
and the value of the tires were about
Doesn't
$50
matter.
a piece.
Okay. I guess I just want to make sure the problem is if we're having, okay. So first probation was for obstruction or retaliation from placed on that probation 2015
Right.
for 5 years. I'm assuming that has been extended. I don't, and then while on that probation, there was a theft of property, was continued on the first probation, placed on probation in February of 2023 for a 5-year straight probation. And now we've got this.
Correct.
Okay, I think at this time, based on the nature of the underlying offenses and based on the allegation and the new offense, based on the fact that there are some obvious mental issues, I don't know that it's in the best interest of anyone for me to let Mr. Dent back out to be doing the same thing. It sounds like he's stabilized. I want to make sure he is. We can get an evaluation done. We'll get you an expert, and then we'll set it for a hearing. But I'm not going to grant the motion setting a bond. I don't think that is in the best interest of our community or Mr. Dent for that matter.
Why can't I, excuse me, I used to tell you this, why can't I do the bond?
Because you're on 2 felony probations and the allegation is that you committed another felony offense.
I don't even think there was
Well, then that's a bigger problem. All right, you can go back with the bailiff.
I don't see that you filed anything. Oh, sure.
Yeah. we just did.
Okay, thank you.
Your recertification?
I don't have it set in complete, I will, you know it immediately.
Did you sign the?
Oh, yeah.
Well, we need it today because if I'm going to send it to her, the case gets closed out and you won't be able to get it.
I'm gonna,
Okay.
as soon as I get my computer, which is next door.
Okay, either way, yeah, just do it before she does the judgment because once that happens, I think the court will close. All right, ma'am, you're Michelle Johnston. And Mr. West, will your client waive the formal reading of the indictment?
She will not.
And so we're going forward today with sentencing and everything?
Yes, Your Honor. We're going forward. We're asking the court to agree for the time to keep served 15 months on the federal case, which would be scheduled for the time I always take to be in the 1.
2. Make it 2, please.
This is information related to federal senate. She was indicted in the federal case in October. And then this case in October, she was claiming and speaking the federal case in October of 2024, and this case ended in having been indicted this year of 2023.
So she started, does that have any objection to that?
No.
So that sentence there was for a 15-month sentence. And so it's y'all's intention that I give her that entire 15 months and that she not be required to go do any.
Yeah. Can't be part of the 41 nights.
I guess issue becomes on these, because it was a federal sentence, that he has not technically been to and received a number from TDC, which is required in this case. So you don't have one on this case.
But when Jefferson County came and picked me up from there and brought me to 9, and I was over there overnight. So I got the ball. So they gave me.
So you have it,
Oh, she has a deal.
but she doesn't have a TDC.
Right. Yeah, but I can bring it.
I don't think I can just give credit and her not go through. I can give her the credit,
Right.
but she's going to have to go in and get a TDC number. It's my understanding. So let's do this. Obviously, if you have credit, we're not going to make you go anywhere today. So just,
She's up there.
I understand what y'all are trying to do, and I'm not in disagreement with that. But legally, I have to make sure that we do it in the right way. Because if you don't have a TDC number, I don't think we can do it that way. The only thing that we could do on a state jail felony, if you want to give her, why don't y'all just do a 1244? That clears it all up.
I don't have a problem.
Because then she doesn't need,
Sure.
she's doing her jail, her time in county jail.
Right.
I'm looking at y'all like y'all are going to help me. I think that makes it cleaner, because she doesn't necessarily.
I'm okay.
In the end, sentences were imposed and bond was denied. Mental health concerns were noted, but community protection remained a priority. The court closed each matter with procedural clarity and finality.